Okay, well, welcome to this St. Philip's Business and Property Juniors Breakfast webinar. The format will be something of a panel discussion where the panelists will take us through different topics in insolvency law and some recent developments as well. The barrister panelists today are Natalie Kearney, who is, I think I can say, Natalie, fast becoming a pillar of the insolvency group and also specialises in commercial litigation. There's also John Aldis, who has a particular interest in the intersection between insolvency, property and probate. And I'm Joel Wallace. I'll be chairing the discussion today. The topics will appear discrete, but if the discussion is steered in the right direction, and I guess that's my job, then hopefully a clear theme will emerge. The topics are first, procedural issues, remote hearings, and the court's general approach to cases in this COVID-19 situation. The second is insolvency and property remedies. And the third is furlough and insolvency and looking at administrations in particular. I should say that you are welcome to engage in this discussion by using the Q&A button and typing questions. I'm afraid I can't guarantee that all, or in fact any of the questions will be picked up and answered, but hopefully I'll manage to multitask and select a few to read out that our panel can address. So without further, let's move to topic one. The first topic is on the temporary practice direction. Natalie, I think you're able to navigate through this for us.
Promises, promises. Yep. So I'm going to talk a little bit about what we've got in the new temporary practice directions. It came into force, as most of you will be aware, on the 6th of April this year, and it theoretically remains in force until the 1st of October unless it's going to be amended or revoked. So the key parts for our purposes really, I think, are paragraph 4, which adjourned all applications, petitions and claim forms currently listed for hearing prior to the 21st of April. So most of you now will have had the orders from the court saying that you're relisted, you're vacated, and frustrating as it was, that should all hopefully now have taken place. Some of you may still be getting adjournments, but we'll come on to that shortly. Paragraph 6 of the new practice direction, all of our insolvency hearings are going to be dealt with remotely by way of Skype for Business or technology as the court requires or the parties agree. So some parties are talking about using Zoom. There's talk of using the new cloud platform, CVP, but at present, the roles building is still using Skype as far as I'm aware, and it is relatively effective. And then paragraph 7 of the temporary direction lists the listing procedure, which is probably of most interest to everyone listening in. So theoretically, the court's going to allocate time slots for groups of winding up petitions and bankruptcy petitions of 2 or more, and each slot will be given a designated meeting link. So the way that's supposed to work is that the daily cause list will go up, the link will be there in the daily cause list, and this will theoretically, one presumes, work for Skype for Business links rather than telephone hearings. But the onus is on the parties to make sure they can use that link to get into the hearing. So what happens if you can't access it? Well, then you need to contact the court clerk, or either the ICC court clerk or the clerks of the BPC to get them to arrange an appropriate link or alternative. It's more important than ever that actually the parties now comply with Rule 7.14 and make sure that if you intend to appear on a petition, you let the petitioning creditor know so that you can be given the details to get into that hearing. You can't show up to the court and expect to be heard. There might not be a judge at the court anymore. So you need to make sure that you've got a telephone number available to be dialed in, or you provide an email address so that you can be given the invite. It's been followed by the circuit guidance for the Midlands, Wales and Western circuits. In essence, what that means is outside of London, they've adopted the majority of the rules as they stand. The difference being that for the Midland Circuit, it's references to BPC staff. Local business remains with local business. And I wanted to talk about a particular case that some of you may have seen on LinkedIn doing the rounds. Shorts Gardens LLB in London Borough of Camden Council. It's two applications regarding the restraint of the two separate winding up petitions being presented. And the reason I think it's interesting is that it sort of crosses over the lockdown period. So the initial application was made in person in London before Mr. Justice Snowden. After that date, there were some further remote submissions put in electronically, and there was a third ground raised at that point, in that one of the grounds for trying to restrain the presentation of the petitions was that until it shouldn't be appropriate to proceed with winding up proceedings until 14 days after COVID-19 is being controlled through vaccination, whenever that is, and or the government makes an announcement that it's safe for the United Kingdom to come out of lockdown. So for those of you thinking that's a little bit ambitious, a never-ending stay essentially on presenting the winding up petition, you would be quite right. The party in that case was trying to rely on a government press release on the 23rd of April 2020, and ultimately Mr. Justice Snowden held that he couldn't make his decision on the basis of suggestions of policy or suggested future intended legislation. He had to do it on the basis of the law as it stood. And on the law as it stood, there was no restriction on the presentation of those winding up petitions. And in fact, he dismissed the applications as being totally without merit, much to the disappointment of the parties.
I think you've provided a useful synopsis there, Natalie. I suppose one of the big questions is here, if you're looking to get your case in the list as urgent, is that a possibility? How does one go about it? What happens?
You can indeed get your case listed as urgent. You need to contact the court, in essence. So if your matter, you think, actually this really needs to be dealt with now, it can't be pushed off. For example, you think it's maybe dissipation of assets, you're seeking a winder, and you think that just by the time you actually get to court, something's going to have happened in the interim. The onus is on the parties to contact the court. I understand some courts might have sent out questionnaires to some parties suggesting do they think it can in fact be dealt with remotely, but not all courts are doing that. But the onus is on you to contact the court clerk, so either the ICC judge's court clerk if you're in the Rolls building, or the BPC staff, setting out the nature of your application, why you think it's urgent. There are presumptions of certain urgent applications. So anything that is, for example, an application for a validation order in relation to dispositions of property, we're looking at section 127 or 284 of the Insolvency Act. Applications in the public interest to wind up a company, those sorts of applications are presumed to be urgent for relisting purposes.
I see. I think we're going to come back to the use of winding up petitions as a mechanism to recover debt at a later point, perhaps. But just moving to the Shorts case, am I right in saying that Shorts appears to tell us that the arguments based on non-legislative provisions will not work? Are we really saying that there is no merit to raising, for example, government statements or things that a minister has said when making arguments that COVID-19 has had an effect, for example, on the business or company?
Well, so it's just in that case would suggest, yeah, that's the case. So the press release was there. He recognised that it said certain things, and that there seemed to be a restriction on certain areas, but on his belief was that it was without merit to raise that as a basis of an application when the court is only able to apply legislation. And I'm sure we'll get to, there are other cases where perhaps the same approach hasn't been taken by other courts.
Well, I think in our next topic, we're going to, I think Shorts will probably feature there too. So let's move on to topic 2 then, the lockdown remedies topic. I think get the slide up. Thanks, John.
Yes.
And John, you're the resident property expert. You take us through this one.
Thank you, Joel. Yes. Well, commercial landlords they normally encounter insolvency procedures in the context of tenants entering into CVAs or administration. Landlords do not typically use insolvency procedures themselves to recover rent from their tenants. And that's because they have better remedies such as forfeiture by peaceable re-entry or the use of commercial rent arrears recovery, or CRA. But this has become a live issue because during the lockdown, a large number of tenants failed to pay their quarterly rent on the 25th of March, and many more will be unable to do so on the next quarter day on the 24th of June. And without government intervention, this would likely have led to a wave of forfeitures, with tenants having to apply for relief from forfeiture and having to pay the rent arrears and the landlord's costs in order to obtain relief. And that would have had all sorts of knock-on effects as well. So to prevent that, the government enacted Section 82 of the Coronavirus Act. In this act, subsection 1 of that section protects business tenants by ensuring that they cannot be evicted by re-entry for the non-payment of rent. So it temporarily suspends the right of peaceable re-entry. Then subsection 2 of that section protects landlords by ensuring that they cannot inadvertently waive their right of re-entry or forfeiture by, for example, demanding rent or suspending rent or taking some other enforcement action. And just to clarify, relevant business tenancy is defined as a tenancy under the Landlord and Tenant Act 1954, so a typical business tenancy. And rent includes any sum which the tenant is liable to pay, so it would include service charges and insurance rent. And the relevant period goes up to the end of the 30th of June of this year. Now, this section in itself does not prevent landlords from forfeiting at least for breaches of other covenants other than the non-payment of rent. And it doesn't prevent the use of CRA or statutory demands or winding up petitions. And so there was talk of landlords increasingly threatening the use of winding up as a means of debt recovery. And then on the 23rd of March 2020, the government made this announcement, which Natalie has already alluded to. It said that high street shops and other companies under strain will be protected from aggressive rent collection, and that it would put a temporary ban on the use of statutory demands and winding up petitions. And it said that those measures would be included in the Corporate Insolvency and Governance Bill. It also mentioned that it would lay secondary legislation to provide tenants with some leeway in respect of commercial rent arrears recovery. There would need to be 90 days unpaid rent. Well, the government has laid that secondary legislation in relation to CRA, but as yet it hasn't laid anything in relation to the Corporate Insolvency and Governance Bill. This is the list of bills which are currently before Parliament, and as you can see, it doesn't mention that one, although you can see the Coronavirus Act has received royal assent. It has laid a cosmetic surgery bill, which I had my attention drawn to, but turns out it's not as interesting as it looks. There's simply going to be a register of cosmetic surgery surgeons. Just to mention quickly, if I could just return briefly to the Shorts Garden case. Natalie has already mentioned that Mr. Justice Snowden in that case said that he had to make his decision based on the law as it stands. But he also looked closely at the press release the government had made and said that it looks like, in any case, this will only apply to companies in certain sections of the economy, particularly related to retail or hospitality, and where the petition is based upon rent arrears, and only where the company is not able to pay its debts due to the coronavirus. So these cases were not particularly good test cases because the petition was presented before the relevant time. They were not tenants in those industries, and they'd already admitted that they weren't struggling to pay, and it wasn't for rent arrears, it was for liability orders. So really it was not on point at all, but it does appear that an argument based on a government press release rather than legislation will probably fair.
Yeah, John, just amused by your list of enacted legislation, a very good visual demonstration of perhaps where priorities are and perhaps where they're not. It seems, John, that landlords are in a real bind with the stay, and then I think it's fair to say, isn't it, that once the stay is lifted, there could be a real backlog which prevents possession applications from being heard going forward. I mean, are you saying really that winding up petitions can't be used as a means of either possession or recovering debt, whether for rent arrears or otherwise?
Well, it can be used until the government enacts any legislation, but there is a wider question of whether that is an appropriate remedy to use in the case of rent arrears. Winding up is a class action, and the court has a general jurisdiction to restrain the presentation of a winding up petition to prevent an abusive process, even if the underlying debt is undisputed and unpaid. If I could just refer you to case of Re Maud, 2015 case, there Mr. Justice Rose said that the pursuit of insolvency proceedings in respect of a debt which is otherwise undisputed will amount to an abuse in two situations. The first is where the petitioner does not really want to obtain liquidation or bankruptcy of the company or individual, but issues or threatens to issue the proceedings to put pressure on the target. The second is where the petitioner does want to achieve the relief sought, but is not acting in the interests of the class of creditors, or that the success of the petition will operate to the disadvantage of the body of creditors. And there is a genuine question over whether winding up a tenant who is simply struggling to pay rent because of the coronavirus could be defended on the grounds of being an abusive process. Now, I should say that this abusive process argument should be used sparingly. That's what Ms. Justice Rose said in that case. And as long as the petition will be of some material advantage to the petitioner, it's unlikely that it would constitute an abusive process. But just imagine a landlord who does proceed to bankrupt his own tenant. The liquidator is probably going to disclaim the lease as onerous, and so he'll be left with an empty property and an unlikelihood of finding a new tenant in these circumstances. And also, is it really in the interests of the class of creditors to wind up a company that may be able to make use of extraordinary government measures to obtain loans and so on to make its way through this crisis and to recover its business at the end of it?
Well, that I think we'll park that topic for the moment. We are going to, I think, come back to it, but just to move things on to the third point for discussion, unless you've got anything further to add, John or Natalie, on that thus far.
No, please go ahead.
Yeah.
There is a question here. What about bankruptcy petitions against non-corporate business tenancies?
Well.
Yeah. I think the similar considerations would probably apply. You wouldn't be presented from using that type of mechanism, but there would be a question of whether that's the most effective one, or whether it would be appropriate in the current circumstances. It is very fact sensitive, depending on whether the debt is due to inability to pay because of coronavirus or some longer term and structural difficulty.
Yeah, I think either way you end up with a property that's empty. If you make somebody insolvent, you end up with no tenant paying you. It's unlikely you're going to get an alternative tenant in this climate. A private individual or company otherwise, you're going to lose money.
And also with a non-business tenant, there's difficulty in obtaining possession in any case with the current stay on possession actions.
Great. Well, great for picking that up. and hopefully that answers the query. If there's anything more, by all means, write in. Let's move along then to administration and furlough, insolvency and furlough, I think it's been billed. I think probably it's for me to pick this one up. The furlough scheme, furlough, one of the lockdown's buzzwords. Everyone, I presume, knows what it's about, but or what it entails. But broadly speaking, it's paid leave for employees, and employers are permitted to recoup that leave or that pay from the government up to 80% of the employee's wages. Let's start with the basic building blocks, just to sort of familiarize ourselves. It takes us a little bit outside the territory of insolvency law and into employment law. There is the HMRC guidance, which was first published back in March. And interestingly, I think there's been about 11 updates or changes to the HMRC guidance in the space of just over a month. So this is a rapidly changing, evolving document. We then have the Treasury declaration. I suppose this is law proper. It's a declaration given by the Treasury pursuant to new powers under the Coronavirus Act 2020, section 71, 76. And it came way after the guidance and way after, I think it's fair to say, the scheme was up and running, or people were making inquiries about the scheme. And as I say, it constitutes a law that underpins that scheme. Of course, the difficulty when you have guidance that preempts a legislative scheme, there's always going to be gaps. I've called them twists and turns, I think it's fair to say. Numerous examples, but one of the big examples was that the guidance said nothing the agreement between the employer and employee has to be a written agreement before you furlough big, or about that being the need to take leave to their employees, and there's been an agreement orally. And the HMRC have agreements in writing. And TUPE, big one, affected administrators and pre-pack sales. There was a big question over whether or not a transferee who took on employees could claim from furlough if the transfer took place after the furlough deadline. I think it was the 28th originally, and then extended to the 19th of March. Again, I think that situation has now been resolved with the guidance, but it shows some of the difficulties that arise. And I think one of the particular difficulties that we're likely to see in the future is that it seems to me that the very act of furloughing, let's say by an administrator, is designed to avoid redundancy and assist with recovery. Well, this act itself might give rise to parallel duties in employment law, such as the duty to consult collectively, which would be costly for administrators, and the failure to engage in such duties will mean that the administrator or the company rather is liable to pay financial penalties, or potentially the administrators, depending on whether or not the employment contract's been adopted. But that's what we're going to come to in a moment. We've got the case of Carluccio's and Debenhams. Those are the recent administration cases. In Carluccio's, in essence, we had a decision before the legislative scheme was put in place. Administrators had sent letters to employees to explain that they would be furloughed, and asked for agreement. And there were three categories of employees: some employees who responded and agreed to being furloughed, some employees who responded and objected, and other employees who didn't engage or respond at all. And the central issue was the basis on which the payments could be made from the government's furlough scheme to the employees. Because, of course, once the administrator claims from the government scheme and the monies go into the company coffers, then they are company assets. And so, of course, the administrator is duty bound to distribute the company assets in accordance with the list of ranking priorities and in accordance with their duties. And if that's to assist creditors rather than employees, then they may find themselves in difficulty, because, of course, the scheme makes very clear that the money is to go to the employees. And the real mooted avenues for payment were Schedule B1, paragraph 66, and Schedule B1, paragraph 99. And paragraph 66 is a sort of broad discretionary power for the administrators to make payments and potentially rejig the order of payments. Paragraph 99 is a paragraph that gives employees super priority, in essence, provided administrators are considered to have adopted the employment contract. They're given a 14-day period from being appointed as administrator, and if they do something, if there is conduct which means that they can be deemed to have adopted the employment contracts of the employees, then the employees will be given super priority. They'll be paid ahead of the administrator, and there could be some real difficulties there for the administrator who's looking, for example, to sell the business on. The court held in Carluccio's that it was 99 that was in play, and it also held that the act of claiming from the government for furlough pay and the act of paying employees as well would amount to an adoption of the employment contract, so the employment contract would be given super priority. This was challenged in the Debenhams case, and whilst the court and later the High Court and later the Court of Appeal found that actually 66 was a perfectly legitimate avenue for making the payments, the effect didn't change. The reality is if you furlough an employee and your administrator and you're after the 14-day grace period, then your claim to the government and or your payment to the employees will be the type of conduct which can be taken as adopting the employment contract, which means that those employees then in turn receive priority in terms of payment. And that can cause some big issues, because whilst the salary of the employee is perhaps taken care of because you've got the 80% from the government, there are all other sorts of pay, bonus pay, holiday pay, being a few, that the company, or sorry, that then take priority in the administration and can make it really difficult to move things forward. Yes. Is there any good news to come from the current situation for recovering businesses? Well, you'll all undoubtedly be aware of the various government schemes to assist businesses, which I think makes times interesting perhaps for administrators with a creative mind who are looking to find box solutions to bringing a business back on its feet. I think I'll just skip ahead and mention very quickly the light touch administration is a very interesting development, which I think comes from America, or is America inspired. Of course, there are some potential issues with this. One is it commercially sensible to let managers who were arguably responsible for the downfall of the company to continue managing? And the second is the administrator free from all risk? Are they liable for the duties of the liable for the sins of the directors? These are all sort of questions that are yet to be answered. I don't suppose either of you take a particular view on the light touch administrations and whether or not there is they're beneficial, commercially sensible, risk-free.
I do, yeah. So I think they're pretty good ways of reducing your administrator's costs and the expenses, and a way of streamlining the process. As you said, there have to be some concerns where, let's say you have a company that was in difficulty before the coronavirus lockdown happened. There's some query whether perhaps entering into a light touch administration is appropriate there, because ultimately the administrator's decision is only going to be challenged by the court if it's so unreasonable and it's a perverse decision, if it's been made in bad faith. And so I think what the court would look at in those circumstances, in looking whether an administrator is liable for letting that happen, is, was it sensible to enter into a consent protocol, for example? And if we had a company that was successful, directors making sensible decisions, the difficulties are a result of lockdown only, it's hard to see that there will be criticism, because ultimately what happened to that company is a result of external factors. And that's not to say there aren't circumstances, it's case-by-case basis where that might be the case, but it seems that it is a way in which administrators can go into a company that otherwise is operating fine and concentrate on how to rescue that going forwards, rather than getting involved in the day-to-day management where it isn't really necessary.
No, and of course the draft wording from the ILA assists with hopefully narrowing the liability of, or limiting the liability of, administrators. So we'll see how that plays out, I suppose. I appreciate we've gone over, but just briefly, there's one question I think draws a thread through some of the topics and things we've discussed. There is this issue, isn't there, that we have policy on the one hand and intention to make policy on the one hand, and then legislation, or perhaps no legislation, but we hope there will be legislation at some point. Are we in a bizarre state where policy has the force of law without being given royal assent, without going through the usual channels? Or are we to just ignore policy and wait for the legislation, as perhaps was intimated in Shorts?
Yes, well, in the Carluccio's and Debenhams case, there the Coronavirus Act had been enacted and the job retention scheme was in place, claims were being made, and the courts were having to interpret government policy in the light of existing insolvency rules and legislation. That's slightly different to the Shorts Garden case, where, as the judge said, he was being asked on the basis of the government's announcement to use this opportunity to help steer Parliament to what would be fair in the mind of public opinion. And he was not willing to take that opportunity. It is interesting that the government seems to think that people must act on the basis of its press announcements. That seems to be the implication of what it said on the 23rd. And in that context, I draw your attention to what Lord Sumption said in an article in the Times. This was a few days after Boris Johnson announced the lockdown. He said, in his press conference, Boris Johnson purported to place most citizens under virtual house arrest through the terms of a press conference, and a statement on the government website said to have immediate effect. These pronouncements are no doubt valuable as advice, even strong advice, but under our constitution, neither has the slightest legal effect without statutory authority. At the time of writing, it is unclear what power the Prime Minister thought he was exercising. So yes, I think we are in strange times where the government is having to act very quickly and is hoping that its press announcements will be enforced, but that's not always the case.
Yeah. Well, and what there is, as you say, colleges and Debenhams where you've got the guidance in place, and the court seems willing to follow the guidance, although it made very clear in those cases that its decisions wouldn't be binding for numerous reasons. But yes, it's a bit of a strain. I think the word unprecedented has been used more than enough times, but I think that's where we find ourselves, certainly in the legal field and certainly within insolvency law. I think that's all we've got time for. I've not seen any other Q&A or questions come in. So I suppose it leaves me to thank everyone for attending. I understand this webinar is being recorded and will be put on the St. Philip's website. I'm sure I'll be told off for not giving you that web link. So I'm going to see if I can put it up now on the screen for everyone. There we are. So that's where you can find the recording for this webinar. My thanks to the panelists, and if there are any questions at all, then please feel free to write in. Enjoy the rest of your day.
Thank you.
Thank you.